Great. So, hi everyone. Good morning. I'm Jamie Jeanette. I'm with Health, Housing, and Homeless Services, and you are here for our monthly training that we offer through the CoC. And let me just give you the correct. Oops. Close your eyes. Sorry. Okay, there we go. Oops. I'm on a different. I'm at my mom's house using a different mouse, so apologies. So today we are here for our Continuum of Care Fair Housing training. Are the slides showing for people?
Yes.
Okay, great. Thank you. So, just a few housekeeping things. So the first thing is we're going to keep all of you muted, and we're asking you to mute yourselves while we're in the session. There will be an opportunity at the end to ask questions, but just to like minimize the chaos. Your trainers will tell you what they prefer, but they did mention, so they'd prefer to have questions at the end. But as we're going, you're welcome to drop questions in the chat, and then we can go back and remember and go see them. So you don't have to hold on to it the whole time, but we might not answer it in the middle of the training. When it is time for questions, we're going to ask folks to do your little raise hand function on Zoom because we can't really see all of you. So if you're like unmute, if you're on screen, we won't necessarily be able to see that. So please, oh my goodness, sorry, different mouse. Also, we will be following up this training with a copy of the slide deck as well as a recording of this. So you will have this as a resource afterwards. And if there are coworkers or colleagues that missed it, they'll be able to look at it that way. And then the last thing is I'm going to do a quick poll. So we always do a quick poll just to see who's here. And let me see. So this is helpful for our trainers and also for us. So the first question is, what best describes your race ethnicity? Why do you care? What we're trying to do is just track for all of our meetings and trainings how we're doing in terms of outreach and also for our continuum of care. How well do our service providers sort of match the population we're serving? So you'll see a couple questions. There's race, ethnicity. We're also asking if folks have lived experience of homelessness. So I'll mention this is all basically anonymous. We're not going to track people's individual answers. We just want to see the big picture. Then we want to find out what's your connection to this work. And again, this helps our trainers kind of understand who's here. What's your role? Again, that just helps them orient their information to understand who's here. And then a question about age. And again, this is really relating to just to see how we're doing in terms of outreach for all these trainings. Okay, so a few ground rules. And I'm going to end the poll in a minute and share out. We only have about half people that have responded, so we'll let it simmer. We're asking folks to respect the trainer, respect the other attendees, make space and take space. These last three, share the mic and acknowledging power and privilege. These are really about just being conscious about what you yourself are bringing to this shared space. So if you're a big talker like me, maybe make some more space. If you tend to be a little more reserved, this might be a good chance to take a risk. Same thing, sharing the mic. We're going to try and have a variety of people asking questions and contributing, and then acknowledging power and privilege. So we all bring different power and privilege into these spaces, so just be mindful of that. Just a quick note, so we do these trainings monthly. So for those of you that are new, you might be like, what is this? So the Homeless Continuum of Care offers trainings for service providers every month. Some are required by our federal funder. Some we've decided as a system of care, really important. We host them pretty much the second Monday of every month, and they're open to anyone, but we really especially want to focus on make sure we're getting like our frontline service providers and managers here so that everybody has the same information so we can provide consistent care and services. As I said, some of them are required by HUD, and some of them are things that we've decided as a local continuum are important. So we are monitoring attendance by agency. And so we will follow up if we see that nobody from your agency is here. And actually, if I say nobody from your agency is here, that doesn't make sense because if you're here, then you're here for your agency. But we will follow up. So just for future trainings, just to note, we want to make sure that all of our agencies are getting this information. goals of this training. So they're going to talk through a little bit more, but just so that you understand like why we're doing this, there are some HUD rules and regs about this, and there are also some written standards ensuring that all of our providers really understand fair housing laws and know what to do if there are some questions about it. As we always do, we're going to just frame as you're walking into this training with a lens of equity. So thinking about, if we're thinking about fair housing, have you noticed inequities in your own work on this topic? Have you noticed that certain populations are experiencing things that maybe are violations versus others? Are there ways that maybe you or your agency has contributed to some of these things or maybe interrupted them? And finally, again, these are all rhetorical questions just to think about it. Like, are there ways that you might be able to address this in the future if you see these things come up? So I want to introduce our trainers. So we have Marissa Jimenez and Monique Doriland, who are both from Bay Area Legal Aid, and they are going to do our training today. So with that, I'm going to stop talking and stop sharing and turn things over to them. Welcome, you guys.
Thank you so much for having us. Let me share my screen here for the slides. Okay, can everybody see that?
It's not quite in the right, it's showing in a different way. So if you go back to, actually, if you go up to the top to display settings, it's a little weird. Like let's see, try again and I'll see if I can coach you. Zoom's always being special. Okay, so go up to the top where it says display settings. I don't know if you see that little drop down arrow. Does it show for you?
More maybe?
Like right above the house. Is it showing display settings?
I'm not seeing the house.
Okay. So if you share, you could share, there's kind of two ways to share. There's like share your screen or share the app. Is anybody else good at coaching how to just what's happening right now is it's sort of showing in our view, like we can see what your next slide is and what the notes are, which you probably don't want. And there's always I'm glad you've done the required technical glitch that the tech gods require for every single presentation ever.
Okay, let me try this again. Share and
Marisa, what I saw on my screen was the first slide, and directly above the slide in the middle of the black was something that said display settings.
Let's see. Let's try again. We're good.
okay.
And when you go to share, there's like an application window. Yeah, let's see. Aha, you did it. Good job. Okay, take it away.
Phew. Good morning, everybody. As Jamie said, my name is Marisa Jimenez, and my colleague Monique Doriland and I will be facilitating this training. Okay. So just a little review about who we are. We both work at Bay Area Legal Aid as housing attorneys. We work in the Contra Costa office, which is in Richmond. And we have Bay Area Legal Aid has 7 offices throughout the Bay Area. And we have different practice areas, and I'll just briefly go through them. The housing preservation and homelessness prevention practice is, again, where Monique and I both practice. We assist clients in addressing landlord and tenant matters, defending against illegal evictions, helping tenants assert their rights under fair housing laws, and combating discriminatory housing practices. We also assist clients with subsidized housing issues, including Section 8 and/or tax credit units. Another practice area within Bay Area Legal Aid is the immigration practice. They provide limited services, including to immigrant survivors of domestic violence. This also includes the VAWA, Violence Against Women Act, self-petitions, and U visa petitions, as well as temporary restraining orders and other services for survivors in conjunction with our domestic violence protection practice. There's the Health Consumer Center, and they assist clients with navigating services from public and private health insurance programs, such as Medi-Cal, Medicare, in-home supportive services, and other county health programs. There's the Veteran Project, and they assist veterans facing issues related to their veterans' benefits, including service or non-service, connecting them to disability benefits, discharge issues, and other issues related to other practice areas. We also have a domestic violence and sexual assault prevention practice. Those attorneys assist with obtaining temporary restraining orders, divorces, child and spousal support orders, safe custody and visitation orders. We also have an economic justice unit. They assist with clients in obtaining access or addressing wrongful terminations or denials relating to income support, such as SSI, SSDI, general assistance, food stamps, CalWorks, and more. There's the consumer law practice. Attorneys in this practice assist with a variety of consumer-related cases, including fair credit reporting, fair debt collection practice, bankruptcy counseling, and advice. And last but not least, we have a youth justice practice. These attorneys.
Yes. I have to.
Sorry, go ahead. I muted them.
Oh, okay. Last but not least, the youth justice practice. The attorneys assist in areas including foster care, health care, access, SSI, education, housing, and homeless youth services. And let's see, next slide. Client eligibility. We may only provide services to eligible clients. Clients must live in one of our practice areas: Alameda, Contra Costa, Marin, Napa, San Francisco, San Mateo, and Santa Clara. Clients must be citizens or be an eligible immigrant. Eligible immigrant includes persons who have an application for permanent residency pending, are permanent residents, refugees, or asylees, or any immigrant who is a victim of domestic violence, sexual assault, human trafficking, or any other violent crime. Generally, a client's income has to be under 200% of the poverty line, except for our consumer center. And there may be exceptions available if the client is a veteran. There are no income requirements for services for health consumer center practice areas. The ways to access our practices is through the legal advice line. Legal advice line is open Monday and Thursday, 9:30 to 3, Tuesday and Wednesday, 9:30 a.m. to 1 p.m. So that is the main legal advice line for all the offices. And in Contra Costa, we also have a Contra Costa tenants rights line as well. The phone numbers are here, and the times that they are open to talk with folks on the phone is the same. All right, so now we're jumping into fair housing laws. There are both federal and state laws that prohibit discrimination in the housing context. Each of these laws provide for protection from discrimination. Some of these statutes are broader than others and provide for larger protections, especially when it comes to protected classes, which we'll discuss on the next slide. Overall, the purpose of fair housing is to prevent discrimination in housing by making it illegal to disadvantage someone in renting, buying, or occupying a home because of that person's membership in a protected class. So here we are on the slide for protected classes. As you can see, there are two columns. The column on the left are the federally protected classes: race, color, religion, sex, familial status, national origin, physical or mental disability. On the right column, it's the California protected classes. So as you can see, California law includes all of the federal protected classes and has additional protected classes. The additional protected classes in California are marital status, ancestry, sexual orientation, gender expression and/or identity, source of income, medical condition or genetic information, veteran status, and primary language/immigration status. What does fair housing laws cover? It covers all aspects of the housing process, from advertising, the application process, the screening, terms and conditions of a tenancy, meaning the lease, and/or eviction and/or termination of the lease. Prohibited conduct under fair housing laws. Intentional discrimination means treating a member of a protected class or a person associated with them differently. For example, not renting to a person because he or she has a disability or because of their membership in any protected class. There's also another aspect to consider, which is the disparate impact. Unlike intentional discrimination, disparate impact describes a situation where at first glance it may not seem discriminatory, but has a discriminatory effect. Here's a couple of examples of disparate impact. Developer constructing a building puts out applications for new apartments. As part of the application to rent, the developer stated that each person needs to be gainfully employed as a measure to ensure residents could afford to pay. The policy had a discriminatory effect on people with disabilities because they are more likely to be unemployed and receive income through other means rather than employment. Additionally, there are two types of sexual harassment. Hostile environment, where there are unwanted sexual advances, and quid pro quo, a Latin term meaning this for that. So as an example, requiring sexual favors for housing privileges. There's also the idea of vicarious liability. An owner can be held liable for the acts of employees, agents, and other tenants. So these are some of the definitions for prohibited conduct. Okay, we have reached our first quiz.
Okay, hold on one second. I'm gonna launch it.
Oh, thank you. Tanya Tennant lives in a large apartment complex in Walnut Creek. She lives in her apartment with her 2 children. The landlord tells her that children are not allowed in the laundry area at any time. Can the landlord institute this rule? A, yes, the landlord has the right to control common areas. B, no, this qualifies as familial status discrimination. Or C, yes, because it is not discrimination based on a protected class.
We can have folks put their answers in the chat, I think. I didn't have these built as polls. I had the other ones.
Oh, okay. Okay, I can't see the chat, but let me see here.
There's a lot of B happening in the chat.
Okay.
People are doing a magnificent job.
Yes, B is correct. Well done.
Thank
Okay,
you.
Monique.
Thank you very much for participating in our quiz. We're sorry we got our quizzes a little messed up. But anyway, my name is Monique Doyle and I'm a housing attorney with Bay Area Legal Aid. And I just want to point out everybody is in a protected class. I'm old, I'm a woman, I'm white. Those are protected classes. Age, gender, or sex, at least in California, and also race. So everybody's in a protected class. The question is not what protected class the person is or is not in. It's more, where is the landlord or the manager or the mortgage company coming from? Are they seeking to deny somebody something because of who they are? You don't have to like somebody. You might decide you don't want to rent to somebody because they have terrible credit. But what if you're deciding you don't want to rent to somebody because they're disabled, because they have little kids, because they're old? So as the slide shows, those are intentional discrimination examples: refusing to rent, sell, or lend, in other words, enter into a mortgage; discouraging applications, requiring different rental terms or rules because of who someone is; enforcing lease terms or house rules differently; segregating through advertisement steering or physical separation. And as some people have already pointed out in the chat, there's a lot of this happening around Section 8 in terms of advertisements. Responding differently to requests for repairs because you don't want to help that group of people with their plumbing, because you want to treat that group of people differently on purpose because of who they are. And that applies also to treating their applications differently. And the relationship between, oh, sorry, I think somebody needs to go to the next slide, which is disparate impact. Thank you very much. So, as Marisa already explained very clearly, disparate impact is a policy that appears neutral on its face, but ends up having a discriminatory impact or a disparate impact on a group of people. So, a policy to evict tenants who call 911 more than twice in 6 months. What if that's happening because someone is a victim of domestic violence? Policy requiring tenants to come to the management office to do an annual recertification. This could be a problem if somebody has agoraphobia, which is a disability. A policy that limits the number of occupants per unit. What does that mean in terms of family status discrimination? And as Marisa already points out, a policy that requires prospective tenants to prove they're employed full time. You can't do that in California. The California Government Code 12955 says that you cannot do that. Can you say to somebody, oh, you have terrible credit? Yes. But that's not the same thing as saying you have to be employed full time. The next slide is the relationship between fair housing. The disparate impact update. I forgot. In April of 2025, the federal government has chosen to eliminate the use of disparate impact liability. And that means that federal agencies were supposed to deprioritize how they evaluate a discriminatory disparate impact. However, remember, it's really important. We have two sets of fair housing laws, Marisa already made clear, federal law and state law. So California still has disparate impact. California still has a lot of things that the federal law currently does not. Okay, I don't know how to make, thank you very much. So one of the things that's important to recognize is that there are extra protections for people who are victims or survivors of domestic violence. And this normally is more clearly playing out in subsidized housing. Although, as we point out here on the slide, survivors of domestic violence often face housing discrimination because of their history of the acts of their abusers. Housing authorities and landlords evict victims under zero tolerance crime policies. People who are seen as problem tenants because the police are always coming. Is that because of domestic violence? Next slide. And I appreciate who's ever doing this. So we are looking here at policies that could violate fair housing law if a tenant is being evicted or threatened with eviction because they are a victim of domestic violence. And we have some examples here, treating survivors differently because of their status as a victim of domestic violence. Evictions for property damage caused by the abuser. And we can answer questions later, but California has a specific statute about that. And I'm now going to make a big important point that applies to a lot of the work that you do. VAWA is the Violence Against Women Act. It protects people in subsidized housing, public housing, project-based Section 8, and someone who has their own HCV or voucher. So if you have a federal rental subsidy, not low-income housing tax credit, but a federal rental subsidy that lowers the tenant's rent, then that tenant should be protected by VAWA. And of course, we don't know what the landlord knows, but this is what the law says. VAWA is intended to encourage survivors who are receiving housing subsidies to report and seek help for the abuse against them without being afraid of being evicted. And I already made the point that this is for people who are trying to get into or who live in already federally subsidized housing. So This includes someone who has a voucher, but it does not cover all private housing in California because if there's no federal subsidy, VAWA is not implicated, sorry. If I could have the next slide, I would appreciate it. So who does VAWA cover? Domestic violence, any felony or misdemeanor crimes of violence committed by a current or former spouse or intimate partner, person with whom the victim shares a child, a person who is or has cohabitated with the victim, a person who is reaching out to try to harm a victim protected from acts under state and local domestic and family violence laws. There's also protections for people who are in a dating relationship or was formerly in a dating relationship with the person who's trying to carry out the abuse. Any non-consensual sexual act prohibited by law is sexual assault, and that, again, in subsidized housing, VAWA comes into play. Also, stalking, any conduct directed towards a specific person that would cause a reasonable person to feel for their safety or suffer substantial distress. And so VAWA is a really powerful set of protections for tenants who are trying to get into or who live in subsidized housing. And these are some of the protections. The right to get out of the lease, that's also true under California law. In private housing, housing providers' duty to provide safe housing, that only exists in subsidized housing. The right to protection from eviction, generally, again, that would be subsidized housing, and the right to have the locks changed. That's, I believe, without looking it up, also true in California law. So there are ways in which these protections, whether it's a California statute or a federal law, directly protect the survivors of domestic violence. And
Oh, do you want me to go back?
I'm sorry, I am not doing a good job keeping track of my notes, and I apologize. So when can a housing provider still evict? If there is an actual and imminent threat to other tenants or employees if the survivor is not evicted. And that's not defined and is very fact specific. HUD regulations here are important guidelines. Threat consists of a physical danger that is real, would occur within an immediate time frame, and could result in death or serious bodily harm. And like any other question in the law, there are multiple ways to evaluate it. Often there are 2 points of view, 2 sides in a lawsuit. Factors to be considered include the duration of the risk, nature and severity of the potential harm, the likelihood that the harm will occur, and the length of time before this potential harm could occur. And what 24 CFR 5.205, what that means is CFR is the Code of Federal Regulations, which is not the same as the Constitution or a statute, but it's very important and often guides, especially subsidized housing analysis. So an eviction should occur only if there is no other action to be taken that could reduce or eliminate the threat. And fortunately for me, we're going back to California law here. The right to break the lease, the right to have the locks changed. This is something the tenant has to ask the landlord to do. The right to protection from eviction. Again, we're in the subset of how are people who are survivors of domestic violence protected by the law in terms of their tenancies. And in California, the landlords must change the locks within 24 hours at their expense if the tenant shows them an emergency protective order or a TRO or some other documentation that the tenant is showing to the landlord. This includes restraining orders, police reports, or statements from qualified third parties. What if you, in the process of aiding this tenant, become aware that there is serious domestic violence happening and this person needs their locks changed? Your description of that to the landlord in an email is enough. And if the landlords don't, within 24 hours, the tenants can change the locks themselves and get reimbursed. Landlords are not supposed to deny housing or take negative actions against tenants or applicants based on their status as victims of abuse or violence.
Mm.
And now we have a quiz that shows up on the screen, and I'm not sure if it shows up in the quizzes that we sent.
It doesn't. I'm so sorry. I thought
No,
this
that's
was.
our fault, and I apologize. So Tony Tennant lives in subsidized housing in Antioch. On September 1st, he was attacked by his abusive partner in the front lobby of the apartment complex. On September 3rd, the landlord serves him, Tony, with an eviction notice for the altercation in the lobby. Can this California landlord evict Tony under these circumstances? And again, this is specifying that Tony lives in subsidized housing. So folks could put their answers in the chat. We would appreciate it, A, B, or C. You guys are once again doing a magnificent job. We are really impressed. And we thank you for your participation in our chat quiz. The correct answer is no, the landlord cannot evict Tony from his subsidized housing because Tony is a survivor of domestic violence. And now I'll turn it back over to Marisa.
Okay, thank you, Monique. Now we are getting into disability discrimination. Under the Fair Housing Act, it is against the law for a landlord or property manager to ask about a disability unless a tenant is requesting an accommodation or applying for housing that gives priority to persons with disabilities. Landlord or property manager cannot discriminate in housing due to a person's disability. They cannot refuse to reasonably accommodate for a disability. They cannot ask a tenant to provide more documentation than is necessary to verify a disability or a need for an accommodation. And they cannot ask a disabled person to prove ability to live independently. Examples of intentional disability discrimination. Steering a tenant to a certain building or floor based on disability or perceived disability. For example, the property management may say, you don't want that unit by the pool because it's noisy and you won't use the pool anyway. Another example is different terms in the lease or conditions or privileges of tenancy. So examples could be the tenant is charged a higher deposit for a motorized wheelchair, but tenants with manual wheelchairs are not charged that higher deposit, or for people who have walkers or canes. Or, for example, the property management won't allow wheelchairs in the lobby. Requesting a reasonable accommodation. I'm sure in your line of work, you've all heard about reasonable accommodations. It is a change in a rule, policy, practice, or service that is necessary to allow a person with a disability the equal opportunity to use and enjoy a dwelling. Disability is mental or physical impairment that substantially limits one or more life activities, and or there's a history of such impairment, and or they are regarded as having such impairment. And in California, the law does not require a substantial limitation. So how do we request reasonable accommodations for our clients? A reasonable accommodation may be requested verbally or in writing, preferably. In writing is preferable because you have the written record. A reasonable accommodation must have a nexus, that is, a connection to the disability requested. This means that the accommodation requested must be connected to the disability and be necessary for the person with a disability to use and enjoy their housing. Best practices for reasonable accommodations: make the request in writing, provide verification from a knowledgeable professional if asked, impairment that substantially limits major life activity, and the need for the accommodation requested. So those last two lines are information that should be included in the reasonable accommodation. When can an accommodation be denied? Under California state and federal law, a housing provider must provide reasonable accommodation unless the requested accommodation has no relationship to the person's disability. Providing the requested accommodation would fundamentally change the nature of the provider's operation or would impose an undue financial or administrative burden or create a direct threat. If the housing provider believes that requested accommodation is not reasonable, then the provider is required to engage in the interactive dialogue to get more information about the disability-related need and to find reasonable alternative accommodations. It's an opportunity to talk and explore solutions and understand limitations and figure out effective alternatives. A reasonable accommodation request does not have to be in writing. Knowledge of need for accommodation may be enough to trigger responsibility under FHA, federal housing. Verification of disability does not have to come from a doctor, and medical privacy rights are still protected by HIPAA. A failure to respond to a reasonable accommodation is a denial. Emotional support animals. So this is always a hot topic. Housing providers, California law, that's what I'm going to discuss right now. Housing providers are allowed to have rules regarding pets, including prohibiting pets. Prohibiting certain types of pets, such as large or wild animals, or prohibiting nuisance activity caused by pets, such as incessant barking. And then here on the slide, the emotional support animal that provides emotional, cognitive, or other similar support to a person with a disability to assist them in managing the symptoms of their disability. That's the definition of the ESA. If a tenant or resident has a disability-related need for an ESA, the housing provider must allow the person to have the animal as a reasonable accommodation, unless the housing provider can show that an exception applies. Some exceptions could be an undue financial or administrative burden, or a fundamental alteration to the housing provider's business, or a direct threat to the health and safety of others. For example, a significant risk of bodily harm, or if the ESA would cause substantial physical damage to the property of others, and that harm cannot be sufficiently reduced or eliminated by a reasonable accommodation. So we have another quiz. Tallulah tenant is searching for a new apartment. They place, sorry, I can't see. They find a place they like because it's near their job and a dog park. They plan to get an emotional support animal once they move. However, when they spoke with property management about the listing, property management told them no pets, no exceptions. Can the landlord institute this rule?
Thank you for putting your answers in the chat. We appreciate it.
All right. Yes, B. B is the correct answer. No, this qualifies as disability discrimination. All right, back to you, Monique.
Thank you, Marisa. So reasonable accommodations, as Marisa has made clear, is when the landlord is asking the tenant is asking the landlord to change a policy or procedure so that the tenant can continue to benefit from the housing. Reasonable modification is slightly different. It's a physical change to the property, and that is a different area of law. It's often very close to reasonable accommodation, but it's got a different title and it has slightly different rules. The tenant has to ask for it, and unless the landlord is receiving a HUD subsidy, for example, public housing, the landlord is not required to pay for the modification. And again, in private housing, if the tenancy ends and the landlord wants to return the property to the way it was before the physical change was made, that would be at the tenant's expense. This is not true for subsidized housing. This is true for private housing. So you ask your landlord if you can put in a wheelchair ramp. The landlord says, okay, but you have to, again, private housing, you have to pay for the installation of the ramp. And if the landlord wants you to, take it out when you move, the tenant with a physical disability. So we don't see as much reasonable modification as we do reasonable accommodation. But it's important to know that it exists there and there are higher expectations of the subsidized landlord. We now have another quiz. This one is true or false. So I think each one is going to be a separate set of answers in the chat. Someone with a mobility impairment can request a parking spot closer to their unit as a reasonable accommodation. And if folks could look at that and decide true or false. And I appreciate your willingness to jump into the chat with a response. And yes, that is a reasonable accommodation. The landlord certainly has the right to ask for verification, and what parking spot is assigned is not crystal clear. This is what Maurice already explained. There's supposed to be an interactive process. Number two, someone who has a severe phobia of spiders can request a parking spot closer to their unit as a reasonable accommodation. What do folks think about that one? I would generally agree with you unless the person with the disability with the phobia could somehow show that there were a huge number of spiders or a bunch of spiders in their assigned parking space. But normally, the presence of a bunch of spider webs, where the landlord doesn't know how to use a broom, is not going to be tied to the location of the person's parking. So generally, I would agree that this is probably false. And thank you, Lori. Number 3, a person with a mental health impairment received a notice of lease violation, which are due to the symptoms of his or her disability. This person can request that the notice be withdrawn as a reasonable accommodation. And again, folks are responding in the chat, and we appreciate that. And yes, the answer is yes, they can. The connection between what the accommodation is and the symptoms of the tenant's disability are always the starting question. So here are other examples. Reasonable modification. Tenant is asking to have a ramp installed. The client or prospective tenant needs an emotional support animal, but no pets are allowed. In California, the emotional support animal is a legally recognized reasonable accommodation for a tenant with a disability. Client's source of income is SSI. Their check comes on the 6th, or automatic deposit comes in on the 6th of every month, but rent is late on the 5th. Reasonable accommodation to change the rent due date. And then clients' disabilities make it difficult for them to move within the eviction notice period. So this is sometimes what we will request on behalf of a client, not that the landlord abandons the eviction of the tenant, but that the tenant have more time to move because of their severe arthritis or asthma or whatever. And I'm going to go on to the next slide. How is fair housing law enforced? The underlying idea, and this is hard to wrap your mind around sometimes, is that the landlord is going to have some sort of penalty, a legal penalty that they're going to deal with if they don't provide a reasonable accommodation to a disabled tenant, or if they choose to treat someone differently in a discriminatory manner because of who they are. So that might be through an administrative claim that can be done online for free to the California Civil Rights Department, that's CRD, or to HUD. And again, that doesn't require a lawyer. It doesn't require any money. You just have to go online to the California Department of Civil Rights and follow the complaint procedure. If people are familiar with employment law, you have to do this first in employment law before you can then go to court. That's not true with housing law, but that doesn't mean that this isn't a powerful tool for someone who believes that they've been discriminated against. It is also something that the tenant can use not just as a sword, but as a shield. It is a defense to an eviction. If the tenant can make the argument that the landlord's eviction of them is rooted in the landlord's failure to follow fair housing law, that it's an act of discrimination to evict the tenant, that is a defense that's available to the tenant. And the last one is the tenant could, or prospective tenant or person trying to get a mortgage, could sue the mortgage company, the prospective landlord, or the landlord. So you might have seen some news a couple years ago. A woman was trying to buy a house on the East Coast, I think in Maryland, and they were very close to the deal being done when her real estate agent contacted her and said, "Oh, the real estate agent for the seller contacted me and they don't want to sell to a Black person." And this woman knew that this was a straight up act of discrimination and a giant fair housing violation, and she happened to be on social media talking about it. And so it got a lot of national attention. And in the end, there was both an apology and some financial uh, exchange between the woman who had said, I don't want to sell to a Black person, and the real estate agents who should have known better, who should not have been a part of this transmission of this absurdly offensive statement and illegal decision, if you will, on the part of the seller. And in the end, that woman didn't buy that house. But this stuff happens in real life. And as we all know, there can be a lot of discriminatory animus on the part of a mortgage company or the seller of a house or a person who is seeking to rent a unit or is currently a landlord. And then we're talking now about other tenant protections. And there we go. So we want to make it clear that the law changed a couple of years ago. If the tenant is served with a summons and complaint, they're facing an eviction for whatever reason, they now have 10 days to file their response in court. It used to be 5. Now it's 10, not including Saturdays, Sundays, and holidays. And what you may all know is that that is an unlawful detainer. In California, we call an eviction an unlawful detainer. The legal process by which a landlord can evict a current tenant. And they have to have a written notice. The only exception would be the expiration of a fixed term lease, where the landlord has then not accepted any subsequent rent from the tenant. Otherwise, there has to be a written notice. And then there's the unlawful detainer filing. The landlord goes to court, and then the tenant has to be served, and they have 10 days to respond. And normally what happens then, the tenant files something called an answer, which means the case is at issue. The landlord almost always is asking for a trial. The tenant can, but they don't usually do that. And roughly within 3 weeks, there is a trial. And I want to stop for a second and see if there's any questions. Okay, thank you for waiting till the end. We switched really quickly from fair housing to evictions. And we also have security deposits, and the law again changed in 2024. A landlord can only ask for 1 month's rent as deposit. So it used to be common first, last, and deposit. They can only, except for furnished housing, landlord can only ask for 2 months' rent. 1 month's rent is the actual rent, the first month's rent, and the other month's rent is the deposit. And this is, you can see that there are a couple of exceptions below that. So the important thing to remember in dealing with subsidized housing, which I know a lot of you do, the landlord under California Government Code 12955, the fair housing statute in California, can't ask a person with a Section 8 voucher to pay first and last at the full amount. 1 month's rent is what the tenant normally pays for their rent. So if the tenant's share is $500 a month, the tenant pays $500 as rent and then the full month's rent as deposit. And that's something that the government code reflects, but a lot of people haven't figured that out yet. And this is tied to what the law calls source of income discrimination. So as you can see, this goes back 6 years. Landlords in California are required to accept Section 8, also called HCV, Section 8 vouchers, and HUD-VASH vouchers, and other forms of rental assistance, if such exists, and to consider them as part of the applicant's income. So in other words, I have a client who has a voucher. She's looking for an apartment, and she's being told by the advertisers or the people online that she's applying to that she has to have 3 times the rent in terms of her income. That would be true and legal if this was private housing, but she has an HCV, she has a Section 8 voucher. The landlord has to figure out, okay, this person, obviously she would have to tell them, well, my share is $500. She just has to show that her income is $1,500 a month because her share of the rent is only $500. So that's a big difference than what a lot of people are familiar with. However, it's been the law for 6 years. As of January 2020. So we have a quiz now, again, with our people with charming names, and the answers go in the chat. Felonious tenant is looking for a place to rent on Craigslist. He finds a listing he is interested in, but the listing states no Section 8 vouchers. But Mr. Tenant also has poor credit. He has applied for the housing, but he is denied when they learn he has a Section 8 voucher. And the question is based on the fact that the question is asking, can the landlord deny him this because he has a Section 8 voucher? What do folks think? We've got yes, because source of income is not a federally protected status. B, the landlord can deny based on poor credit. And C, no, because source of income is a protected status in California. You guys are doing brilliantly in the chat. Yes, even though Section 8 is a federal subsidy, source of income protection is based in California law. And we're talking about a California tenancy here in Contra Costa County. So we're not saying that the landlord can't deny based on credit. The question is, can they deny based on felonious tenants' Section 8 voucher? And the answer, as most of you saw, was no. And then we're going to look at the Immigrant Protection Act next. A landlord is not allowed to ask you about your immigration or citizenship status.
I don't think the slides are showing. Is that correct? Can other people not see the slides?
Oh.
I saw it on my screen, but
Can other people see them?
Yes, we can see the
Oh,
screens.
that's weird. Okay, something's happening for me. Sorry, Carrie.
I think we need to go back one more because we were going to talk about immigrant. Yeah. If you live in federally subsidized housing, the landlord must ask about your immigration status because not all immigrants would qualify to live in subsidized housing. There's a bunch of exceptions. We're happy to talk at length about that. But it's okay for the housing authority or a project-based Section 8 place to say to somebody, what is your immigration status? And ask for copies of, and I'm sure you've all done this or seen this in a tenant file, birth certificates, driver's licenses, and green cards. But in private housing, landlords are not allowed to bring this up because it's completely irrelevant and it should not be an issue. And we have certainly seen situations where landlords who want to intimidate tenants will threaten to call ICE. That's vile and it's also illegal. And you can see here under California law, disclosing any information related to the immigration or citizenship status in order to harass, intimidate, retaliate, try to convince someone to move out, or recovering possession of the dwelling. Possession is a word that only landlord tenant lawyers and judges use. It's a concept. It is the idea that when you rent or buy property in our legal system, one of the things that happen is that you get possession of it. So you know this on a common sense level. If I show up at your door tonight, whether you rent or own, you don't have to let me in because you're in possession. You decide who enters. Go away, crazy legal aid lady. You don't have to let me in because you're in possession. And normally possession is something that is transferred with a key. So when you rent and you've signed all the paperwork and everything's approved and you get the key, you're in possession. But the key is just a symbol. Possession is, if you're extremely rich, you're, I don't know, some millionaire, some billionaire from Silicon Valley, you could be in possession of 5 houses in California, Maui, Idaho, New York City, and Paris, and rent another one in New Orleans for Mardi Gras. You can be in possession of multiple places, but most human beings don't have those financial resources. So possession is something that the landlord might want to recover for some other reason, but it's not okay if they bring up the tenant's immigration or citizenship status. And I think we have another quiz. So again, we're going to ask you very patient people to answer in the chat. Tamara, tenant rents a studio from landlord. She has a green card. During her tenancy, Tamara's studio required several repairs. She provided written notice to her landlord asking for the repairs. Landlord didn't respond right away. After 3 weeks, landlord finally said he'd get a repair person out to her unit. I'll send someone. But nobody came. It had been a month. So she contacted code enforcement. And code enforcement for the city she lives in came out, investigated, and said, wow, this doesn't meet the law, and issued a notice of violation to the landlord that they have to make repairs. The landlord got upset because, as you've all figured out, this is unlawful discrimination, and that's what you're putting in the chat. And he says she has to go back to her country and sends her a text message threatening to contact ICE. It's illegal, and she should seriously consider contacting the California Department of Civil Rights. So I appreciate your usage of the chat, and I think I turn this back to Marisa now.
Thank you, Monique. All right, we have reached the case study. I will read the case study, and you can put your thoughts in the chat. So, issue spotting. Tawny and Tybalt are looking for a place to live. They begin their search for an apartment with the help of a housing navigator. Some of the postings they find say things like, must be gainfully employed, or no Section 8, or only credit scores over 750, or no kids allowed. The next day, their housing navigator speaks with property manager Penny, who says she has an apartment available right now. However, when the housing navigator tells Penny that Tawny and Tybalt will be using rental assistance to pay for the first and last month's rent and deposit, Penny says she doesn't want to rent to anyone who cannot afford the rent without having to use rental assistance, and that the deposit would have to be increased to 4 times the monthly rent. What issues are we spotting here?
Trying to just say, what do you think is an issue, and put it in the chat.
Mm-hmm.
And I was just going to mention there may be some folks that are not able to chat. I don't know if you're open to taking any folks unmuting to say anything.
Yeah, sure. You can say, say it out loud too.
I'm seeing a bunch of stuff in the chat, just FYI.
Okay. Check the chat here. Yeah, discrimination, Discrimination against source of income, exactly. Discrimination, illegally charging 4 times the rent, yes. Landlord demonstrating prejudice, unfair housing practice, low income population. Yes, you guys are getting this. So, right, in the advertising, the gainfully employed, that is a disparate impact and source of income. No Section 8 source of income, intentional discrimination, no kids. Yeah, there it is in the chat, no kids, great. All right, you guys knocked that one out of the park. Next up, after some legal advocacy, Tawny and Tybalt are approved as tenants and they move in. Soon thereafter, Tybalt was involved in a car accident and suffered a spinal injury. He was able to walk, but only short distances. Tybalt's doctor provided him with a disabled placard so that he could park close to his destination. At his apartment building, there were parking spaces, one of which was right in front of Tawny and Tybalt's apartment. Tybalt asked Penny to assign that parking spot for him because it is difficult for him to walk long distances, and the parking spot is close to his apartment. Penny, property manager, told Tybalt, "You look fine to me. Plus, it's not fair if I give you a parking spot up front because other tenants have lived here way longer than you. If you want that spot, you need to pay for it." What issues do you spot here? She should not have a job. Disability discrimination. Fire Penny. You look fine is inappropriate. Failure to meet reasonable accommodations. Disability discrimination. Discrimination for housing. ADA discriminations. Yes, you're picking up on all of these issues here.
And we should point out, as silly as it sounds, this has literally come up in lawsuits where the people who are being sued, the landlord or management company, are like, they didn't look disabled. Um, we don't make this stuff up. And you're right, also disrespectful.
Yes, Amy Ortiz. Okay. Yeah, feel free to, say your answers out loud. Okay, so later that week, Tawny received an email from Penny stating that the property management's corporate office ran an audit and found that one of the required rental application forms was missing from Tawny and Tybalt's application file. Pamela asked Tawny and Tybalt to complete the form called Getting to Know You. The form included questions such as, what country were you born in? Do you speak English? Are you married? How many children do you have? Do you have a disability? Are you a veteran? Tawny wondered why they had asked to provide such personal information to property management. Tawny responded to Penny's email declining to complete the form. Property management Penny replied that it was a mandatory form, and if they do not complete it, they will receive an eviction notice for breach of lease. What do we think about this one? Questions are in direct violation of tenant rights. Exactly. Invasive questioning, illegal questioning, illegal questions. Too intrusive. These should be optional questions as they are for employment. Yeah, good idea. Again, you discovered all the issues here. Did I go too far? Okay. So a reminder, how is fair housing enforced? There are administrative complaints that can be filed with HUD or the Department of Justice. And there is defense work in unlawful detainer evictions. And there are civil lawsuits, which would include damages, meaning money, and injunctions. Injunctions are a legal mechanism to either have someone do something or stop doing something. And we have reached the end of our training. Again, here is our legal advice line and all in all the practice areas, the phone number and the times and days that they are answering the phones. And now we are open for questions. So if you'd like to put them in the chat or just unmute and ask us, that's
Sorry,
it's
can
your
you
choice.
go back to the last slide?
Oh yes, no problem. Here you go.
Thank you.
Of course. And all this information is also on our website at Bay Area Legal Aid.
And while folks are thinking, I'm just going to drop in the chat a link to our survey, but we have plenty more time if folks want to hang out and ask questions. As I said, we've been recording this. We're also going to share out the recording on the slide deck via email. This is the
Yes,
great.
Estefania.
Yes, I do have a question. Many times we work with a community which, for example, tenants are like co-tenants, and sometimes they pay their rents in cash. They don't have their name on the lease, etc. Can this be can this be used as a resource, for example, when it comes to those barriers?
Are you talking about the legal advice line?
Correct.
Yes. And I could also weigh in and say that like subtenants or co-tenants who live there but may not be named on the lease, they can certainly ask either their master tenant or the person who's in charge of paying rent to the landlord to give them a receipt. It doesn't have to be something fancy. Sometimes people will buy like a little receipt book and just, fill it out and have their master tenant sign it. Or even the landlord for that matter.
And there was a question in the chat about, can we help people figuring out whether an eviction is quote unquote on their record, which is a very loose term. There are private companies, you've probably heard of them, Experian, TransUnion. There's another one, I always want to call it Transfax, but that's not what it's called. And they are large private national credit reporting agencies. And if someone reports that you, for example, owe them money to a credit reporting agency, something might be on your record. That doesn't necessarily mean that if you got sued for eviction, it's going to show up. It depends on whether you lost and whether someone reported it. Currently, in Contra Costa County, it is hard to find out if someone was sued for eviction and lost. The court does not release that information unless you have the case number, the street address, the name of the plaintiff, the landlord, and the name of the tenant. But as I put in the chat, we have a walk-in clinic on Monday mornings at our office at 1025 McDonald in Richmond. And it's a walk-in clinic for tenants. And this is the sort of thing that might make more sense for us to talk directly to somebody. Anybody can come to the clinic. It's a free walk-in clinic, 1025 McDonald. It's right around the corner from Kaiser. And mostly what we're focused on in the clinic is helping folks who got sued get an answer ready to file at the court. But in general, we could address whether something was, I'm not sure. I saw somebody write in the chat that an ID might need to be shown. I'm not sure that's true, but you would generally need to know the name of the case. You know, Marisa Jimenez versus Monique Dorland, the case number, MS 240132, and the street address, 1025 McDonald, Richmond, California, 94801. So I wouldn't say that you would have to show ID at a courthouse to get information. But for evictions, you would need to have these other pieces of information. And we encourage people to call the phone numbers on the screen. We can't help hundreds of people at our walk-in clinic, but it is another option. And please ask more questions because I have a tendency to talk too much, and I apologize.
Other questions folks may have? You see if there are any from the earlier there. I feel like there was a question earlier in the chat. Let me just look. Hold on one second. There's definitely something kind of early on.
Yes and no. There's something called the Mrs.
What was the
Murphy
question?
exception. Are people who rent rooms obligated to follow fair housing laws? There are exceptions to most fair housing laws if I'm sharing the house with someone. And we are generally focused in this training on commercial landlords, whether nonprofit or for-profit, who have an apartment complex or renting out a house. Not so much about roommates or Marisa rents me a room and we share the same bathroom and the same kitchen. There are less fair housing rules for Marisa. No, the landlord cannot charge the tenant extra for an emotional support, animal, client rights within SLEs. SROs, single room occupancy. I'm not sure if I know what a
No.
CLE is.
An SLE is a sober living environment, so it's typically like they rent a room and there's an agreement. It's they rent a room, there's often like food and you're supposed to be clean and sober. Maybe there's like recovery meetings, but they're not really regulated. I don't know if other folks have things that they want to say about that, but they kind of fall in an interesting area for this. I don't actually know the answer.
We can do some research and try to get back to you. My off the top of my head response, there are fewer protections for people who are in a SLE than in regular, I'm a tenant, you're a landlord. But we can do some research and get back. Yes, exactly. There's actually more protections for SROs. We don't see that many single room occupancy hotels in Contra Costa anymore. For people renting rooms in a house, I guess that would be a local code question. Is the landlord allowed to rent to whoever they want to? In general, if you ignore subsidized housing where the rent is created by a series of federal regulations and HUD subsidy or even low income housing tax credit or LIHTC, the current way that a brand new tenancy begins in Contra Costa County in private housing, regardless of what town you're in, yes, they can charge any amount of rent they want. This is just private housing, no subsidy. There are restrictions on how much the rent can go up after that in Antioch, in Concord, and in Richmond. But the initial amount is probably whatever the traffic will bear. And how many people can rent would probably, I don't know, what do you think, Marisa, tied to a local ordinance of what the landlord's supposed to do in terms of health and safety laws?
Yeah, I think that's a good point. There may be some local law or ordinance stating like no more than 12 people in a, however many rooms unit.
We will try to, one thing you should know for an SRO, not some sort of specialized thing that's for people in recovery, but a straight up single occupancy hotel room, the landlord is not supposed to make the tenant move every 28 days. There's an explicit legal prohibition on that. Does it happen? Yes. Are the tenants vulnerable and they go ahead and change their rooms because they don't want to have a hassle with the management? Yes. But that's illegal. And the reason why landlords do that is once you've been there for 28 days, you're a tenant, as opposed to me renting, a room at the Best Western. I'm not a tenant. But if I'm in a single room occupancy hotel room for more than 28 days, I am a tenant. If a client has a housing voucher but does not have a rent portion, can they be denied? Well, I would say yes, depending on the facts. If the tenant is presenting somebody as I have a voucher, I have zero income, and the housing authority is going to pay 100% of my rent, the landlord could still, I think, legitimately refuse to rent to them because of a history of bad credit. And Marisa, what do you think?
Yeah, I think it would be pretty fact specific. Um, if the tenant could show that they had good credit in the past, but just don't have um, are not employed now. Um, yeah, I think it would be based on the specific facts and, advocacy around that.
Sorry, this is a lot of what lawyers do. They say it depends. And we're sorry. Does this apply to room and board locations that are unlicensed in terms of rules? Um, I think that a room and board location would still be subject to California tenant protections. Um, I don't think the fact that you're giving people food changes that, whether you're licensed or not. I think that's something we could try to research and get back to you, just like the question about SROs and SLEs.
That might be a
Um,
reasonable accommodation.
That would be great because I think a lot of our folks are actually getting housed in situations like that. And I think it is murky.
yeah, we need to know more about it. I think a lot of times people feel very vulnerable. I've had cases in the past where a landlord in Richmond was renting out a bunch of rooms and imposing rules on people. And there were a lot of what I viewed as both fair housing and habitability violations, but the tenants felt very vulnerable. There was a question there about disruptive or aggressive behavior. That is not so much about room and board, but what are the fair housing rights of the tenant who is disruptive? And you have a low credit score. That's the same question as before in a way. The landlord is allowed to say you have a history of getting evicted and not paying your bills. Therefore, I don't want to rent to you because I don't think you're going to pay the rent. Which is different than an eviction history. Um, and I think I'm smearing your question, Brianna, into two different fact patterns. Um, yes, that's true. For a long time in Southern California, landlords did not provide refrigerators. And you can still make a deal that you bring your own fridge because most people in Southern California have their own fridge. But I don't think we finished with Miss Bernal's question. Members who has no eviction history is currently employed but has a low credit score. That's a really good question. They have good rental history, no prior evictions, but they have a low credit score in general.
That seems like a wobbler too. And perhaps sometimes letters of reference may like tip that for the landlord, especially if they have good rental history.
Yeah, that they've rented from someone before. Maybe that prior landlord is willing to say something to this new prospective landlord. Oftentimes, credit history, especially now, a lot of people are searching online for a place to rent, especially somebody who just has a voucher or is just in private housing as opposed to like trying to get on a waiting list. And yeah, I know they get denied. It's we should do some research on that. Is your credit history in and of itself in strict private housing? Probably the landlord can make an argument that I am making a business decision. This person has crappy credit. Yeah, they got a job now, but I don't care. I don't know, Marisa, what do you think?
Yes. And if it affects the tenant in a detrimental way, they may consider filing a complaint with the Civil Rights Department, California Civil Rights Department.
Again, you want to look at the parts O and P of California Government Code 12955. It's written in a kind of confusing way, but it talks about source of income discrimination. Would I don't like your credit rating, but you've never been evicted, fall into source of income discrimination? I don't know. Thank you, Ms. Franco, very much. In the chat, a link to the Civil Rights Department of the state of California. And I think the question that Teresa Cox asked about, I'm renting out rooms in my house, but I don't want people to use the oven and the stove. And as you point out correctly, there's a new law. It would be interesting to look at that. Is the tenant renting out a room and being denied use of the kitchen? Is that legitimate? If it's held out as a room with no access to a kitchen, I don't know. I don't think that's legal. I know it happens. Marisa, what do you think?
Yeah, I don't think that's legal either. And I think I would hope that there was something in the lease that did not include a prohibition in terms of like, you're not allowed to use, or maybe that would be better for the tenant. You're not allowed to use the refrigerator or the stove. Again, I would think of a CRD complaint with the Civil Rights Department.
Would
And
that
we
impact
understand that
habitability? Like, I think one of the ways that I talk about like what's considered homeless is this place not fit for human habitation? And I feel like access to plumbing, electrical, but I don't know if that's legally holds up.
the problem is in reality, you're talking about a subset of people who are really vulnerable. And renting a room from a creepy landlord who denies them their rights is better than being on the street. And the question is, does the tenant have the ability to assert their rights? Um, I would say in the SLE context, where, as you say, there is no lease, it's not a regular tenancy, it's something else. We're on some listservs with housing providers and large nonprofits who focus on tenant rights in California. We will ask on the listserv what other people think and get back to you via email. Um, I- how, it used to be that people would rent a room and they would go out and get their meals somewhere else because there were a lot of small diners, but we're talking like the 1930s. That has changed a lot. And it can be a very complicated situation. I was part of some litigation for a single room occupancy hotel on McDonald in Richmond about 20 years ago, where the original idea was that there was a shared kitchen and a shared bathroom, but the assumption was that the people who lived there were gone all day because they were working. But in reality, at this point in time, the people who lived there were not gone all day. Most of them were on SSI or had no money and they didn't have a job. And they had a lot of takeout food in their rooms. And it was a very complicated and ultimately horrible situation. And the landlords got sued. And the tenants successfully got some money because we represented them in an affirmative case against this SRO owner. But an SRO is different than a place that holds itself out as an SLE. And that's what we need to do the research on and get back to you about. Bed contract. I'm renting you a bed and you're going to be in recovery, but you have nowhere to eat is nuts. I'm sorry. And we know that there's a lot of folks who rent a room on a very informal basis, sometimes with an oral agreement with somebody who's subleasing to them, themselves are a tenant, or, a garage. And people are desperate for a place to live that they can afford. And we know that there are really a lot of permutations of this. And it's really easy to pretend like everybody rents a regular apartment in a regular apartment complex from a regular landlord, and that's just not the truth. Did Estefania have a question?
Yes. I do have a question when it comes to undocumented people who rent and stuff. There's many times concerns also about eviction and we know that they don't have a social security number to be tracked if they get evicted, etc. I just wanted to see if there's any way that even being evicted as an undocumented individual can impact for them to get housing in other places. I know also like there's situations that is happening of mixed families also living under Section 8, that there's either one person undocumented and they're concerned about losing potential housing and their new policies coming up. So I don't know if you wanted to speak to that a little bit more.
Or you said, I've been talking endlessly. Do you want to talk?
Can you repeat just the last part of the question, please?
Like, for example, what have you observed, for example, in mixed status families who have about housing voucher in either one individual who's undocumented and they may be fearful, and scared they might lose housing because there's new policies changing when it comes to HUD, right? Who will get access to housing applications. So it's something that is it's being, it's coming up, it seems like. So I wanted to get a little more of what is your input or your feedback when it comes to this population?
One thing important to remember is that there's a traditional concept in HUD subsidized housing called mixed status. and that is not going away as far as we know. There was a public comment period. Mixed status is where some people in the house have a green card or a citizen's, and other people in the house are undocumented. And always those families had to pay more rent. And to my knowledge, mixed status still exists as a category for people in subsidized housing, public housing, Section 8, project-based Section 8. And so the rules might change because there was public comment about an administrative rule that HUD was talking about. But I do not think that they have yet finalized the rule. And I don't think that they're getting rid of mixed status because we would have heard about it. I'm not saying everybody should relax and be calm and oh, don't ever worry. I'm just saying at this point in time, a family with some undocumented members can still live in subsidized housing. The problem is often the undocumented members are the head of household and they're the people working, and the rent is higher than it would be for someone where everybody has a green card or a citizen. And it's still lower than regular market rate housing, but it's a big burden. But we don't think they've gotten rid of mixed status. A person who owns a home told me people who rented the room was have a microwave and a mini fridge, but could not use the stove. I know. And I mean, I feel like there's this, I'm putting this in the chat, there's this gray area where people rent a room in somebody's house and it seems like they have less rights. And is that legal, I guess, is the question. And we will do some research. I know there are less for housing protections, but that's not necessarily the same as you can't receive mail here. You can't use the kitchen.
Well, going back to this one, a person who owns a home told me people who rented the rooms. So does the landlord live in the house, or it's more of a like a boarding home? Either way, some advocacy may help. And I think there are different bodies of law that, could be relied on. Like Jamie mentioned, the habitability laws of California, as well as the ideas and protections here in this training we've discussed. And as Monique brought up as well earlier, local rent control, if that's an option.
Right, but the voucher. Oh,
Yeah.
this person should come to our Monday clinic or call. It's complicated because we don't always know the funding program that's provided a rent subsidy to somebody. If somebody, obviously this is HUD subsidized, that's the 30% of their income, not of the rent, but of their income. But ideally that person would come to our walk-in clinic or call us on the phone because there's only about 100 questions we would need to ask them. I'll put
Yes,
the address in the chat again.
What was that, Monique?
I was just going to put the address here in the chat again for Monday morning's clinic. Of course, I can't type.
We welcome any more questions. And or if you have some good news you want to share from some of your clients, we're happy to hear that too.
Hi, my name is Rolando at Lau Family. I have a question. Well, two questions. I don't know if you answered. I was going in and out earlier. I apologize. But one is, can you speak of that Section 8 rule that they can only charge 3 times the amount of rent based on their subsidized portion that's allotted to them? For example, I have a client, $700 subsidy, and Section 8 pays the rest, but the landlord, of course, wants 3 times the amount of rent. So I would like to take that information that I think you talked about earlier, or it was only 3 times the 700. Is that correct?
Correct. I just put California Government Code 12955 into the chat. That's
Okay.
the piece of law that spells this out down at the bottom in parts O and P. It's worded in a way that's a little confusing.
Okay.
But if you can find that law on the internet, one way to look it up is to go find the actual legislator's website, which is CalLeg. And then you have to pick what section of law you want, in this case, government code. And then you type in 12955, and that will bring up the law without any like analysis by a lawyer on a private website or something. And you scroll down to the bottom, and I don't know how much longer we have. I can try to look it up and put it in the chat.
That would be awesome. The other thing is, again, I don't know if I heard you earlier. Did you speak of child support? I have a lot of participants who need child support assistance. I know I used their legal aid in the past, and the problem was a lot of my participants want to know how they can get it lessened. They don't feel like they should be paying it as much, especially working with the reentry population who has been on vacation, I call it, for a while, and then has this large child support bill once they are released. I was wondering if you could speak of that, or I can speak with you offline. Thank you.
Well, yeah, I would recommend you call or have your clients call the legal advice line, and they are able to provide general information about those topics.
Yes, we have called the legal advice line, and he has went to an appointment with them, and the outcome was still the same. They couldn't offer any kind of assistance. And so I had, last time we spoke of this, I had recommended that he get all his documents together from, you know, that he has, especially and first and foremost, the county, his case number, and we can go from there. But nothing sufficed from that. Nothing was that, there was no outcome from that. I was just wondering, is there another direction I can take?
Yeah, I'm gonna add. So I used to work pretty closely with Jamie Luna, who works in the Department of Child Support Services. And I know they've been really active. She actually used to come to all the homeless court sessions. And they are actively working on how to reduce actually what people owe so that they can get work, get on their feet, and, kind of like then be able to actually bring in more income to help support the families. So I just dropped a link in the chat for their website, and they actually have this whole like interactive chatbot thing that they've built. This is actually a thing that they really want to support people with, especially as you said, reentrants and other folks where they're so afraid of how much they owe that they're just like staying off the grid completely. They want to work with those folks. So I strongly encourage reaching out to the Department of Child Support Services.
Also, this is what the law says. So this California Government Code 12955, Part O, Subpart 1, in instances where there is a government rent subsidy, like Section 8, to do either of the following, and all of these are illegal. This is the law starts out saying it's illegal to use a financial or income standard in assessing eligibility for the rental of housing that is not based on the portion of the rent to be paid by the tenant. So it's worded in this, legislators, lawyers in Sacramento wrote this, and it's not that clear, but that's saying if you've got SSI and you have a voucher, so you realistically can pay the rent. The landlord can't say you need $4,000 to move in. You need 900 to move in if your share is 300. And again, only it's not going to apply unless the tenant has a Section 8 voucher.
Okay, thank you. Thank you both. I appreciate your time.
I want to flag we have about 5 minutes left, but we can definitely use that 5 minutes. And just a reminder before folks hop off, we do have a quick survey that we're asking folks to fill out, and we'll send an email with that link to the survey as well. But it just helps us make sure that we're getting you the information that you need so you can support participants. If there are other questions, now is a good time, and if not, we can be done.
I do have a question. As a legal aid organization, do you know any, do you refer the community, for example, if they're at risk of losing the housing due to being behind on rent? Because I know it's really challenging to connect with those resources for emergency aid. And I know sometimes when it comes to connecting them through 211, it's really challenging even to kind of complete the screening and then also have the agency follow up with the patient in this case. So what recommendations or how do you support anyone in our community when it comes to getting access to these resources?
I understand what you're saying, and I share the same frustration. It is very difficult to speak directly with some of the rental assistance agencies, and you know, sometimes I do have to let my client know you have to call and go through 211, and it can be very confusing and stressful and difficult. I don't have a good answer. What about you, Monique?
When we're actually representing a tenant, like we're their lawyer, we will help them with the Keep People Housed application, which is a website application that can be a little daunting. But it's not like we're set up to help hundreds of people apply for Keep People Housed assistance. That tends to be for tenants we're defending in an eviction. So yes, Estefania, in a limited sense when we're representing somebody. But other than that, we can obviously we have conversations with clients or people in the clinic about, there's Shelter Inc., there's Catholic Charities, there's Seasons of Sharing, there's the county. You're supposed to get rental assistance if you have CalWorks and you ask for it. And there is the Keep People Housed. How much rent can be raised and how often? It depends on where the person lives. Are they living in subsidized housing? Or if they're in private housing, are they in Richmond, Antioch, or Concord? Because how much the rent can go up is dependent both on whether it's private or subsidized housing and the locale or the jurisdiction the tenant lives in. So there's a California statute, the Tenant Protection Act. I don't want to quote the statute off the top of my head because I don't want to get it wrong. I think it's 1947.12, Civil Code 1947.12, but that might be wrong. That for certain types of housing, which basically breaks down to apartments, there is an amount, 10% or less. Marisa, do you remember off the top of your head how the TPA controls rent?
Yeah, generally speaking, if the house is 15 years or older, then it is under the jurisdiction of the California Tenant Protection Act. And the California Tenant Protection Act is the California rent control. So if there's new construction, then if the building is 3 years old and it's not a subsidized building, it would not be, that new building would not have to comply with that 10% cap.
And there's also, depending on who owns the building, single-family homes are often exempt from the rent and eviction protections of the Tenant Protection Act, but the exemptions have to be shared with the tenant in writing. Estefania, did you have a question?
Yes, since we're talking about the rent increases, I wanted to ask if you have a website that we can further, like, for example, I know that you can enter someone's address and verify if that's actually under rent protections. I'm not sure if you're aware.
We would tend to look at where somebody lives and try to figure out if they are in Antioch, Concord, Richmond, or if they're in subsidized housing first before we would analyze whether a rent increase was legal.
And that's why it's also very important to ask these questions when we support someone in a housing crisis to verify, like you're saying, is that private, subsidized housing, further screening about their income, how long they've been living there, if they have anything that they have put in writing through their landlord, etc.
Exactly. Yeah, that's a really important screening issue to bring up with your tenant, with your client.
I just want to note we're at time, but I want to encourage folks to reach out to Bay Area Legal Aid and Monique and Marissa specifically if you have more questions. I will be following up with all the information and really appreciate everybody. Thank you, Monique and Marissa. Thank you all for your really great questions. Sometimes, we have a training and it's just kind of like dead silent afterwards. So this was great. You had lots of good questions. This is a really complicated topic. So I encourage you to definitely reach out to professionals when you have questions so we can make sure folks are getting all of the things that they are entitled to, all the protections. Thank you, everybody.
Thank you, everybody. Hope you have a good day.
Too. Bye, all.